Yes, Your Honor. Chris Enos on behalf of the appellee.
We are here for oral argument in Ibarra versus Gastelum, our case number CV190597. Counsel, we have reviewed the record, including your briefs. We've considered the case. We're familiar with the record. We encourage you to keep that in mind as you present your arguments. Each side will be allocated 20 minutes for oral argument. Appellant, Mr. Abney, you may reserve a portion of that time for rebuttal if you wish to do so. If you wish to do so, you need to keep track of your own time, given that we don't even have a podium clock these days, and I'll be informally keeping track of the time as well on my end. We're recording the proceedings. We have some court staff in attendance as well. And would ask that as you present oral argument, you start by telling us your name and the party that you represent. With that, Mr. Abney, you may proceed.
Yes, Your Honor. I just noticed in my picture that I'm not wearing my coat. Do I need to put my coat on or else?
Let me look to my colleagues. I think we're in a position to move forward. Are you okay, Judges Swan and Howe?
Yeah.
I'm shocked. Shocked, I say.
Please proceed, Mr. Abney. I appreciate that.
Well, in any event, I think that the appeal, like most of my appeals, seems to come down to one point, whether there should have been a negligence per se instruction based on ARS section 33-1324A2. My colleague across the aisle says no, because that's not specific enough, and he points, I believe, and founds much of the argument on the Schaefer versus Murphy case, where a tenant had leased an apartment that had a number of things wrong with it. The kitchen and linen closet weren't painted. The floor tile was missing in the bathroom. The draperies were not hung. Several of the interior doors were not in place. But the one thing that the Supreme Court and the trial court focused in on was that there were two toilets in the apartment and one was described as inoperable. There's no other explanation or description or detail about what the inoperability was, whether it simply couldn't flush or whether it was leaking or making noxious smells or what it might have been. It just simply did not work, although there was another toilet that did work. And the Supreme Court, the trial court said, well, the premises were not habitable on the day that the lease was to begin, in violation of the Residential Landlord-Tenant Act. At the discussion at the Supreme Court cited the two sections that have become of interest here. The first one is the one that we're relying on for the negligence per se. The landlord shall make all repairs and do whatever is necessary to put and keep the premises in a fit and habitable condition. Was the first section that the court was dealing with, and the other section was the one that deals with maintaining in good and safe working order certain items, including plumbing. The trial court said, okay, it's not habitable. I assume that the trial court's decision on habitability must have been based on the toilet problem. Not having paint and not having some tiles in and draperies not hung and some interior doors not in place, that would not make an apartment not habitable. It may not make it very enjoyable place to be, but you can certainly live in it. But having a bad or inoperable toilet, I could see where that would be a concern to the trial court, and it was a concern to the Supreme Court. But the strange description that they have here is it says the Act sufficiently defines fit and habitable to include maintenance of plumbing facilities in good and safe working order. I went through the statute, the Residential Landlord-Tenant Act, and especially 33-1324, and it doesn't say that anywhere. Where I think the Supreme Court was using a shorthand to say that if you do have something like this, it's bad enough that it makes the place uninhabitable, and therefore you would have a right to a relief. And here we've got a situation that is quite dangerous. Unlike the inconvenience of having one of your two toilets not working, this is a condition that posed a very present danger to people living there. And apparently, over the years that this thing, this crack developed and got worse and worse, the Ibarra just lived with it. And like so many people, you get used to the danger surrounding you and don't really think about it too much until one day he cuts his toe badly and things go downhill from there medically until there's an amputation. But I think that Schaefer would stand for the proposition that if you have something of this type of danger in your home that would be regarded as unfit and uninhabitable under section subpart A2, and that would be enough to support enough specificity to support an instruction for negligence per se. That's really the heart of my argument. Are there any questions at this point?
Mr. Abley, let me ask you, that reading of Schaefer would equate something like, say, a broken window that had jagged glass that could cause great harm to a house that, for example, didn't have running water. Is that your position? Is that how you read Schaefer?
Yes. I think if you had a broken window that had sharp and jagged edges, that could pose a danger. Not having any running water at all would certainly be anybody could agree with that that's unfit and uninhabitable. But having a dangerous window like that, it could be. So much of this would really have to go to the trier of fact. You present the instruction on negligence per se and let the trier of fact figure it out if that is a situation where there really is negligence per se.
But that again is the question is the specificity sufficient under the Schaefer analysis? And the cases leading up to Schaefer do talk about it's not just sort of every obligation that would satisfy the duty and breach aspect of a negligence per se instruction. Fair?
That is fair, but perhaps a better example would be a window that's stuck, that you can't open and close. You have air conditioning or you have a cooler and you can live without having that one window go up and down. It just doesn't work. There's a difference there between having a window that doesn't work and one that's broken out that could pose a danger to anybody who actually came into close proximity with it and tried to do something around it. You could accidentally cut yourself. So I think maybe that's a better example.
And so that's the line that you would draw?
The line I would draw was something that would create a danger to people. The term that was used, good and safe working order is in subpart A4, but fit and habitable is in A2. And if a toilet that doesn't work makes a place unfit and uninhabitable, then a room with a jagged, broad crack down the middle of it is much worse than that, I would submit, as far as health and safety are concerned, and would make it uninhabitable.
Isn't the point here, though, that we're supposed to have specificity so that we don't have to have debates like this? It seems that you got a trial with a negligence instruction. The negligence instruction says basically you have to act reasonably in the circumstances. How is that any different from the spectrum of defects that you're describing? Aren't you just asking us to make a determination of what's reasonable in the circumstances? No.
The jury had an instruction on basically the standard common law duty, as you will, and the problem with the basic common law duty is, unlike subpart A2, which is a positive enactment, you must do certain things.
Let's stop there. Let's stop there. Your paraphrase is, or your abstraction is questionable. You must do certain things. It doesn't say what certain things you must do. It says you must do things. So it seems to me that the statute really addresses a point in the argument earlier, a point where the landlord would say, hey, I lent you, or I let you this property, you owe me the rent, and we're done, much like a commercial lease. And then the tenant could come in and say, no, this statute imposes a duty on you to act reasonably to make it safe. That is different from this statute tells you that you must have working toilets, working windows, holes, no holes in the floor, no mold, whatever it may be. There isn't a standard to instruct on other than this person, by virtue of being a landlord, owes what is essentially a common law tort duty. as I read it. Can you help me textually figure out how that's wrong?
Well, it's beyond the common law in one essential aspect is there's no requirement of notice. Under subpart A2, you must make all repairs and do whatever is necessary to keep the premises in a fit and habitable condition. No ifs, ands, or buts. You have to take positive action to do that. And I assume that there's a subtext there that you really need to inspect it once in a while to make sure things are okay. But in any event, whether you inspect or not, you are liable if you fail to make all repairs and do whatever is necessary to make it fit and habitable. Now, what is fit and habitable is a fact question for the jury to decide.
But isn't negligence per se usually reserved for those cases where there is no fact question? You know, the speed limit was 45 and you were going 70. That's not really, I mean, there may be a fact question as to whether you were going 70, but it's not a fact question as to whether 70 violates the statute. Here, there seems to be a fact question that is perfectly cognizable under negligence, but has no place in traditional negligence per se.
I'm not sure about that. If you say you must maintain a specific speed, and then the question is, did you violate that speed or not? If you must maintain the premises a fit and habitable condition, then there's a question of whether you maintain them in a fit and habitable condition. In both cases, there's going to be a question of fact for the jury to sort through. You give the jury the standard and let the jury decide if the standard's been met.
But isn't the negligence per se analysis more like this, where the defendant might say, sure, I was going 70, but it was reasonable in the circumstances for whatever reason. And you have the negligence per se instruction to say, no, as a matter of law, it is unreasonable to be going 70 in a 45. That kind of argument doesn't really, that structure of that argument doesn't fit with your case. Because there's no statute that says what the minimum, I mean, every floor is going to have cracks, right? Even a smooth concrete floor is going to have microscopic cracks. So what's the largest crack width permitted in a residential lease? The statute doesn't say. It doesn't say anything about cracks. It seems to say simply that landlords cannot use a duty argument to evade liability.
I think it does more than that. I think it imposes on the landlord specific things that have to be done. The exact nature of what has to be done in any particular case is why we have the jury to decide if there has been a violation of the negligence per se standard.
So if I move into a really hip warehouse space with distressed wood flooring that has cracks naturally in it as an aesthetic feature, much as many expensive doors have that feature, are you saying that that's negligence per se?
Yes, but you're also sort of conflating in there the defense that would be coming up, and the defense would be, well, you had it's not open and obvious danger, and therefore you should be at least partly at fault. If you step into a crack in a distressed floor, it's your own fault. Or if you get a splinter from a distressed floor, that's your own fault. But
I agree with everything. I agree with everything you're saying. That sounds like a reasonable argument in a negligence case. But why is it negligence per se?
Well, the original duty, if you violate the duty, then there's a negligence per se. And if then you can say as a defense to that, okay, we violated the duty, but you are at fault as well. And therefore, under 122506, the jury has to assess percentages of fault.
Okay, and then with apologies to my colleagues for taking so much time on this line of questioning, I need to then go into the language you used, which is if you violate the duty, it's negligence per se. That seems to be either circular or at best sort of a chicken and egg problem. If you violate the duty, then you have committed negligence, not negligence per se. I hearken back to Markowitz, which says, okay, here's this general duty. We're not going to talk about what the content is. That's up for the jury in each case. How is this really any different from a legislative enactment of Markowitz in a landlord-tenant situation?
As far as I understand the question, the statute creates a duty. If you violate the duty, then you have negligence per se. It sets a standard. You have negligence per se, then you can go to the jury and say, as defending and says, okay, I committed negligence per se, but my responsibility needs to be reduced or even go away because this other person either assumed the risk or was contributorily or comparatively negligent.
How do you, well, I see Judge Howe has a question. I'll yield.
Well, Counsel, I'm having a hard time though trying to draw the line between what's specific and what's general. And do you have a rule that we can apply here?
The rule I think we have to derive out of Schaefer, and unfortunately it's not the clearest opinion in the world, but the court believed that the act itself had sufficiently defined what fit and habitable means. Using as an example, an inoperable plumbing facilities or plumbing facilities not in good and working order. That seems to sufficient specificity for the Supreme Court that I believe they're really leaving that issue to the jury to resolve, saying fit and habitable under these conditions means, and the jury decides what fit and habitable means under those particular conditions.
Isn't that exactly what happened in this case?
No, because the jury didn't get the negligence per se instruction. The
But
jury,
got
decided the landlord
the
had
jury
no
got to determine the jury got to determine whether the landlord had acted reasonably in the circumstances, right?
Yes. Also,
And concluded that he did.
No, because there wasn't a specific interrogatory to that effect. The jury could have simply decided the landlord did not have notice, and there was a lot of time spent in this proceeding trying to say the landlord had no notice, that the relationship between the landlord and the tenant was not very amicable, not very open flow of information, and the landlord didn't know that there was this crack. And at trial, of course, the landlord has shown pictures of the floor, and he says, yes, that is unreasonably dangerous. He admitted that right at the trial. But he apparently had not been inside that house for years, maybe decades. I couldn't tell from the record, but it was a long, long time he hadn't been inside. So, yeah, there's a lot there that the jury could have said, well, he just didn't have notice. And if you didn't have notice, you're out the door. Not that you acted as a reasonable landlord necessarily, you just simply did not know what was going on inside the home. But subpart A2 doesn't say anything about knowing. It says you have to make all the repairs and do whatever is necessary, whether you know about it or not. If you don't know about it, well, I assume the law is basically saying it's your own fault and you're liable.
What if the windows aren't properly flashed and the apartment or the house becomes damp or there are water stains during heavy rains? Is that covered?
May not be a very fit place, but I assume it would still be habitable until the mold starts to develop and everybody drops dead. I mean, there's a long range of things that can happen there when you get a condition like that. But here we're dealing with something very clear and straightforward. Even the landlord admitted it was unreasonably dangerous once confronted with it, actually. You had this crack, and of course, what happened. He cut his foot, cut his toe, and had it infected and couldn't be treated properly and had to be amputated. If I may reserve my remaining whatever time I've got.
You may, and I have it about 2 minutes and 40 seconds. Mr.
That seems fair. Thank you.
Very well. Mr. Enos, answering.
Thank you, Your Honor. My name is Chris. I represent Edward Gastelum in this matter. I think there is one issue before the court, and I think appellate counsel talked. We have different views on it, obviously, as we've set forth in our brief, and as I'll talk about with regard to some of the questions raised. The biggest concern that I have here after listening to some of the questions is that what's the real purpose of the Arizona Residential Landlord and Tenant Act? And I think it can be argued that that's basically an implied contract between landlord and tenants, says what needs to be done by both parties, and then provides remedies for those issues. But none of which I'll mention before now or have anything to do with it.
Mr. Enos, your microphone seems to be cutting out, or at least we're not hearing everything clearly.
I'm sorry. I'll try to speak slower. If you can't hear me, give me like a hand.
We will.
I appreciate it. I think that when you look at the Landlord Tenant Act as it plays its role in our statutes. It's basically to set up an implied contract between the landlord and the tenant on what the duties are for both, okay, as far as those issues. But they're contractual in nature, they're not tort in nature. Negligence in a premises liability setting has been the same in Arizona for years. It's under common law. And the way it's set up is very simple. And the instruction that was given instructed and properly instructed the jury in this case. If the court would have given the instruction, it would have been error on a couple of reasons. Number one, it doesn't have specificity. It's as general as it possibly can be, frankly, with regard to the statute cited by the appellant. There's no specificity there. It's very, very broad. Secondly, so it should fail on that ground. Secondly, if it's given, you're basically turning premises liability law for the landlord tenants into a strict liability situation.
Mr. Enos, let me ask you about that, because Schaefer, applying the Landlord Tenant Act, appeared to adopt in the right type of case, right type of claim, negligence per se. So wouldn't that undercut or be contrary to your argument that that couldn't happen?
Well, and again, I think it can happen. And again, the court wrote what the court wrote, and I understand that. And I understand that that is slightly maybe damage to our argument that there never should be a negligence per se instruction. But I do want to argue to this court that that's a very dangerous box to open, because what you do there is, again, you can make arguments, I assume, with regard to the other elements of premises liability. But much like I had in a motor vehicle case years ago, where I had somebody backing up from a parking spot, there's a statute that tells you you can't back up until you can back up safely. There's no duty required for anything else in a motor vehicle. However, my guy backs up, does not see somebody walking in a parking lot, and there's an ACL injury that takes place as a result of the incident. My client testified, I looked in both side mirrors, I looked in my rear view mirror. I did everything I could to back out. I backed out slowly. I didn't back out quickly. And unfortunately, I struck this guy. Plaintiff says, I was paying attention. I just didn't see him. He came out, fairly close to me, and I didn't have time to get out of the way. My argument in that case was, you know what? Sometimes an accident is just an accident. And if you're in a shopping center and you come around the corner, sometimes you run into somebody who's going one way, you're going the other way, and it's nobody's fault. There's nobody that's negligent. I got a defense verdict. It goes up. Court of Appeals says, no, there's negligence per se instruction was given. You have to be found at least 1% at fault. I think the premises liability area makes it so that giving this instruction would be error in the fact that notice is built into the common law. And I do not believe that the Arizona Residential Landlord Tenant Act attempted to change the common law. Because if they wanted to, they would have. I wrote it down, I think there's 51 statutes in the Arizona Residential Landlord Tenant Act. There's 5 separate articles. One of those articles deals with remedies. What you can do when someone's not doing what they're supposed to under the act. There are 18 statutes under that section. Not one of them talks about the fact that you have a civil course of action for personal injury damages as a result of the violation of the Landlord Tenant Act. I think they're apples and oranges. With regard to prejudice and given instructions, it would have added nothing. What appellate's counsel was argued today is the same thing that was argued and presented by evidence at the trial. He presented everything. And he was given the premises liability statute, which discussed all of these things. And remember, notice isn't just always actual notice. It's something being there long enough that you should have known about. And the jury had the opportunity to make its determination based on that. There's no indication of any error. The judge gave a perfectly rational basis for not giving the jury instruction, which was he did not find it specific enough. Then I just don't see how, under the facts and circumstances and the way this particular statute is written, how it can be defined as being specific. It's just not. With regard to and again, most of that's wrapped up in our oral argument or in our pleadings. With regard to questions that were somewhat raised in appellate counsel's argument, I think the court discussed some of the things that need to be looked at with regard to making a ruling and determining whether or not it was proper or improper. And I think the basic thing behind it is you have to look at the purpose of the statute, and you've got to look at the arguments with regard to, I guess, appellate's main argument that, hey, it sets forth the fact that it has to be fit and habitable. And then he talks about Schaefer and how it should extend here. The problem with that is it kind of goes against also what's directly in the statute, because there's a set, I wrote it down, I think, Arizona Residential Landlord and Tenant Act 33-13-24 talks about the fact that not only does a tenant have to give notice of an issue with regard to problems with where they're living, you have to do it in writing. I'm just not telling somebody, hey, I need you to have a problem. I need to set it forth in writing if I want to avail myself of appropriate remedies. That was never done here. There's nothing in the trial court record to indicate that Mr. and Mrs. Ibarra ever gave notice to Mr. Gastelum in writing of the problem. They argued, and I think they argued extensively during their testimony, that they had told him that there was a problem, that he should come look at the problem, but they never notified him in writing, and that is required under the same act that appellate's counsel relies on for giving the negligence per se. With regard to, I'm sorry, it's 1341. I gave you the wrong number. I apologize to the court. With regard to some of the factual questions, which I don't think play a huge role here, I think appellate's counsel mentioned that they didn't know how long Mr. Gastelum had, kind of ignored this issue. But remember, the Ibarras had lived there for numerous years, I think 15 or 16 years. Mr. Gastelum didn't become the owner until a year before this incident. To argue that this is not fit and habitable when they said they've had the crack all along, it doesn't make sense from a common sense standpoint. If it's not habitable, how are they there for their entire time within this this apartment, living and going on with life until this event actually happens? And
wasn't there evidence at trial that the crack had gotten worse over time? That it started, and at the end, it was a fairly significant crack, right? A couple inches deep, a couple inches wide.
Yeah, there's no doubt about that, Your Honor. I think, as we know with houses and buildings in general, things tend to get bigger over time, not smaller over time. And there was testimony from the Ibarras that, in fact, it had grown over time. It had grown over time, but that didn't change the nature of the crack, other than it got larger. And again, when we talk about specificity, when we talk about the Schaefer court, they're talking to toilets that are specifically listed in the act. So even if it would apply, it would apply there. Floors are not. And the legislator very easily could have written that in if they thought it needed to be written in. The fact that it grew, I don't think changes the nature of it. And it still doesn't change the specificity problem that we have. And again, the argument from our standpoint would be it really doesn't matter, because the contractual elements under the Landlord-Tenant Act are apples, and the premises liability, personal injury stuff are oranges, and they're separate and distinct here. I mean, if the legislator wanted to make this strict liability, they could have wrote into it like the dog bites. If something gets hurt in your residence because you haven't done everything you're supposed to take care of and make all repairs, you're strictly liable for anything that comes out of that, including not only contractual issues, but also tort issues. And the court did not do that. Or excuse me, the legislator did not do that. I thought there might have been one other question that was coming. I heard it, but I didn't see where it was coming from when you first started your question, Your Honor. I don't know.
I think Judge Swan and I may have had the same question, but I'll defer to Judge
Well,
Swan.
I don't know. My question, first of all, I was going to point out, it doesn't really work as a definition of habitability to say that the tenant was still there. Right? There are people who live in premises that violate the warranty of habitability all the time. So that gets us really nowhere, I think. It's not your position, as I understand it, that a negligence per se instruction could never be issued under this statute, is it?
I think that it would have to be very careful, and frankly, I don't know that it should be. And I know that there's the case law that's out there, and I understand that. But I do think that when you look at the purpose of different statutes that are entered by our legislator, they're for different purposes. And to argue that the Landlord Tenant Act is one for safety to be used in premises liability, I'm not sure that's the reasoning that I would follow. And again, that's not up to me, because when I look at this, I look at it as somebody who's in a very unfair bargaining position from the tenant. And that's why there's a lot more responsibilities and duties put on the landlord. And that's why it gives the tenants not only the actions that they should take, but also the remedies that are available under that act to make sure that they're not being taken advantage of, and they don't have to deal with the fact that, you know what, their air conditioning's not working, their plumbing's not working. Maybe in this case as well, that, you know what, the landlord should come in and try to fix the floor, do something to try to remediate it. I'm not saying that that's not in fact an issue. If this case had been a case about we want to get out of our lease or we want a reduction in rent, then I think the arguments are that, yeah, the landlord had to comply. And there's an argument that he didn't. And that instruction in that particular circumstance would be absolutely appropriate.
Mr. Enos? Yes, Judge Swan, yes.
No, go ahead. I was just looking at a quote in Schaefer, but I can wait. Go ahead.
I think I've kind of wrapped up what we've set forth and the arguments that we made and why we have made them. If there's other questions of the court or things that come up, but I mean, simply in this particular case, we don't believe the jury instruction was appropriate. It didn't add anything to what was already given to the jury. The arguments were made by plaintiff's counsel at the trial level and evaluated by the jury prior to rendering their decision. Obviously, there's a question with regard to notice, and that's the argument that appellant makes, is that they should have been told that in this particular case, there's notice doesn't matter. If this thing wasn't fit and habitable, and here's your jury instruction. If it's not, it's negligence per se, and you need to make a finding for the plaintiff. And based on our system and the way that premises liability has been set up forever, I don't believe that would have been a proper instruction. The second argument is even if it was, they got the notice issue through the jury instruction. They very easily could have said, yeah, fine. Mr. Gastelum says he didn't get notice, but both of the plaintiffs have said that they told him about it. When he saw the crack, he admitted that it was large and it was dangerous. I'm not sure he's an expert or he can talk about whether it's dangerous or not, but he gave the testimony that it was dangerous. All that went to the jury, and the jury rendered a defense verdict based on those facts and circumstances. So the only question is does this court want to extend negligence per se to this situation? Because that's what the court would be doing if they go ahead and follow appellate's argument, because they'll be taking the jury, you guys would be taking the jury decision away from the jury with regard at least to a defense verdict and saying, no, you can't do that here. We think it's specific enough. We don't believe it is, but we think it's specific enough. It should have been given, and the defendant would have had, or appellee would have been found at least some percentage of fault, and therefore we're remanding for a new trial on that basis. And I just don't believe that's the proper conclusion for this court to come to this matter.
Thank you, Mr. Enos. Mr. Abney, rebuttal.
Yes, Your Honor. Thank you. The Schaefer said, quote, "We find that an inoperative toilet is a condition materially affecting health and safety," end quote. There's no reason why a jury could not find that a floor condition like this jagged, deep crack, was not also a condition materially affecting health and safety. And
I don't deny that, Mr. Abney, that a jury could find that, but I'm wondering whether your interpretation of this statute, and your case seems to rely entirely on subsection A2, I wonder if that would really make other subsections like 4 and 5 and 6 superfluous. I mean, if we were to interpret the duty in A2 to be so specific as to give rise to a negligence per se instruction, why do we then need to mention electrical, plumbing, sanitary, heating, ventilation, all these things that have specific requirements if there's just a general catch-all anyway?
Well, the difference is good and safe working order is different from fit and habitable. For instance, you could have a washing machine that works badly but still works, and if that's not in a good and safe working order, then you might have some responsibility. Or you might have ventilating system that works sort of, not really incredibly well, but it works. Or all these other things that are mentioned, that they work, they just don't work in a very good and safe way.
Well, can't that be said of the floor in this case?
I think that the floor poses a danger, a direct danger.
Well, yeah,
walking through there.
It didn't work in a good and safe way, but I mean, nobody fell to their death. The floor was a floor. It just wasn't good and safe. Isn't that really what those more specific subsections, which I think probably could give rise to a negligence per se instruction, are getting at?
I think they're trying to provide some more specificity for landlords and tenants to understand exactly what kinds of things are involved. But as far as an overall standard, I think the reason that you have that make all repairs and fit in habitable condition subsection is number 2, right underneath comply with the requirements of the building codes, is that because I think the legislature intended it to be sort of an overall broad approach to the duties that landlords have. They have a positive duty, and that's, my colleague talks about there's been no change in the common law. This is a radical change in the common law. That's why the legislatures in Arizona and across the nation have these uniform residential landlord-tenant acts in place, because the common law was not working to protect tenants' rights, health, and safety. And with the Landlord Residential Tenant Act, you've got that sort of protection, and it really does approach strict liability. You've got to go out there and you've got to make the repairs. You got to do whatever's necessary to keep it in a fit and habitable condition. If you don't do that, then you're liable. It's a good law. I think I've basically said my say, and if I've got any remaining time, if there's no questions, I'd like to give it back to the court.
Thank you. Your remaining time has expired. Council, we appreciate your presentation today. We appreciate your briefing. We will take the matter under advisement. We'll issue a written ruling in due course, and court stands adjourned. Thank you much.
Thank you, Your Honor.
Thank you.